a window breaks, a photo resurfaces, and suddenly a game built on fiction is dragged into reality. What you thought was background art, evidence. What you thought was a title, a trademark war. This is intangiblia. And today we follow the fractures.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to the podcast where creativity meets control schemes and legal drama spawns faster than a plumber with a shiny star. I'm Leticia Caminero. Well, her AI version, of course.
And I'm Artemisa, your AI co-host, coded for commentary, sarcastic side-eye, and the occasional copyright connection.
In this episode, we're diving headfirst into the legal Sidequests no game developer asked for, from names that trigger trademark claims, to fan-made modifications that got taken down, to a certain shattered glass photo that cracked open a lawsuit.
We'll take you through some fully rendered pixel-perfect cases, a few deep dives, and sprinkle of rapid-fire glitches, all stitched together with IP threads and plot twists worthy of a cutscene.
And yes, we used AI to build this episode, voice, research, delivery, all filtered through a human lawyer's judgment. So no, we're not replacing creators. We're just making the loading screens more interesting. For this episode, I built an escape room style game called IP Sidequest Showdown, available on our website, www.intangiblia.com. In the game, you're a rookie IP agent tasked with cracking some legally inspired mysteries. Solve all the missions and the briefcase unlocks. Drop a comment if you crack the code or if the clone got you first. Our first stop, 2020, Ubisoft is gearing up to release a mythology-based open-world adventure with gods, monsters, and a few puzzles on the side. They call it Gods and Monsters. Clean, simple, epic. Until a certain beverage company stomps in with its claws out and a lawyer in each hand.
Monster Energy filed an opposition against Ubisoft's trademark. The issue? The word monster. Apparently, if your game's title includes it, even if it's about Greek gods and mythical beasts, Monster thinks you're stepping on their fizzy toes.
Monster Energy argued that gamers might confuse their drinks with a video game about Zeus and floating islands. Ubisoft tried to explain that their monster had wings and fangs, not caffeine and carbonation, but legal pressure escalated, and so did the need to rebrand.
So Ubisoft blinked. They renamed the game Immortals Fenyx Rising. More poetic? Maybe. Less likely to be confused with an energy drink? Definitely.
It wasn't the first time Monster Energy pulled this kind of move, and spoiler, it wouldn't be the last. But this was the case that made it clear. Even the title of games can be dangerous territory.
Especially when a brand thinks it owns an entire noun.
Because Ubisoft wasn't alone. After that, Monster Energy went full rage mode, challenging game titles left and right, like it was on a trademark speedrun.
Next up, Monster Hunter. Yes, Monster Hunter, a franchise that predates Monster Energy by years and has zero to do with beverages. That didn't stop Monster from trying to block its trademark renewal in certain countries.
Then they took a swing at Pokemon. Yes, that Pokemon. Over the name Pokemon X and Y Pocket Monsters. It didn't land, but the attempt alone raised eyebrows high enough to trigger a level up prompt.
And indie developers weren't safe either. They went after Dark Deception, Monsters and Mortals, a horror party game with spooky characters and zero sugar content.
Most developers either fought back or settled, but the legal drain was real. Monster Energy didn't win most of these, but their tactic was loud, expensive, and exhausting.
It's what some call trademark bullying, using a big legal budget not to win, but to wear the other player down.
So next time you see the word monster in a game, just know it might take it a few rounds with legal before it made it to your screen.
And no, it won't make you more energized, but it might make you more cautious about your game title.
Okay, let's talk ink, not contracts, skin, because in 2020, one of the most unexpected copyright lawsuits hit the gaming world. And it all started with LeBron James's shoulder.
Welcome to the case of Solid Oak Sketches versus 2K Games. Solid Oak had acquired the copyright to 5 tattoos, real tattoos, on real NBA players featured in the NBA 2K video game series.
So when 2K rendered those athletes in game ultra realistic, every tattoo included, Solid Oak said, "You using our art without permission, pay up."
And they didn't ask for chump change. They were aiming for millions in damages. To be fair, it wasn't the first time this argument showed up. Remember The Hangover Part 2? Mike Tyson's tattoo artist, S. Victor Whitmill, sued Warner Brothers for using his iconic tribal design on Ed Helms. That case didn't go to trial, but the judge did call Warner's fair use defense, and I quote, silly.
Back to NBA 2K, this case did go to court, and it raised a big question. If an athlete's body is part of their identity and their tattoos are part of that identity, can a company show the player without also showing the ink?
The court said yes. They ruled that the tattoos were a minimal part of the overall image, were used with implied license, and importantly, helped create realism. Fair use, case dismissed.
It was a win for realism in sports games, but it also left the door open because this case was about usage in context, not about tattoo copyright disappearing entirely.
So if you're a developer scanning body art into your next big release, just make sure your realism doesn't come with a lawsuit.
From realism to rebellion, we now move into one of the most poetic legal moments in gaming. This time, it wasn't about stealing, it was about restoring.
Enter Take-Two Verse, the modders behind Re 3 and Re VC. Fans who loved Grand Theft Auto 3 and Vice City, like really loved them, decided to reverse engineer the original games, not to copy, to fix.
In the ruins of old code, fans unearthed a forgotten kingdom, GTA 3 and Vice City. They rebuilt them, fixed bugs, added features, and breathed new life into the classics. The games looked better, played smoother. It was preservation. It was polished. And it was about to get pulled.
Because Take-Two sued. They said the fans had used parts of the original games without permission. That's unauthorized distribution of copyrighted material. And they didn't wait around. They fired off DMCA takedowns,
which for non-lawyers means they send legal notices to platforms like GitHub demanding the mods be taken offline. It's the digital version of pulling the fire alarm, fast, automatic, and hard to fight.
The modders argued back. They weren't copying, they were reverse engineering, a legal gray zone where developers take something apart to learn how it works or make it compatible with modern systems.
It's a real legal defense, but a risky one when you're dealing with one of the biggest publishers in gaming.
After a public backlash, the lawsuit vanished like a hidden Easter egg. No final verdict, no major punishment, just one of those rare endings where the Sidequesters walked away.
And a quiet reminder, sometimes the best remaster is the one fans do themselves.
With better lighting and fewer bugs.
Some legal fights are subtle. This wasn't one of them. This was the digital version of you copied my homework and didn't even change the font.
Riot Games had created League of Legends, one of the most iconic competitive online games in the world. Moonton, a Shanghai-based studio, released Mobile Legends. And let's just say the resemblance was uncanny.
We're talking character designs, map layouts, gameplay mechanics, even the marketing materials felt like deja vu. So Riot sued in the US, Moonton pulled the game and then relaunched it days later under a new name, Mobile Legends Bang Bang.
Bold move. Didn't fool anyone.
Riot sued again, this time in China. Moonton's parent company, ByteDance, had deep pockets, and things got even more complicated. Legal ping pong across jurisdictions began.
Eventually, Riot took the fight back to the US, and in 2018, they won a $2,900,000 0 cents judgment. But the game stayed online, the fans stayed loyal, and Moonton just kept updating it.
This was more than just a lawsuit. It became a long-term standoff about what counts as copying in games. Where's the line between inspiration and imitation? And what if the clone becomes more popular than the original, at least in some regions?
The case settled in 2023 with both parties dropping their swords behind closed doors. No epic win, no press conference, just silence. And a whole lot of money probably changing hands.
If anything, this saga showed just how hard it is to protect a game's feel, because in IP law, you can copyright a character design, but not a gameplay vibe.
And in clone culture, sometimes the sequel starts before the lawsuit ends.
Our next story starts with something small, a texture. A broken glass pattern you'd barely notice while dodging zombies in Resident Evil, but it turns out that crack was real.
And so was the lawsuit. In 2021, photographer Judy Jurchek filed a massive copyright infringement suit against Capcom, claiming they used over 80 of her copyrighted images in games like Resident Evil 4 and Devil May Cry.
The images came from her 1996 reference book, Surfaces, a physical and CDREM collection of architectural and material textures, things like bricks, marble, stained glass, and yes, shattered glass.
Capcom allegedly took those images and inserted them directly into game environments' doors, windows, flooring, without asking, crediting, or paying.
Now, here's the twist. How did she find out? Capcom's own files were exposed in a data breach in 2020. In those leaked internal documents, file names matched the ones from her CD REM. Side-by-side comparisons went viral.
It was like the zombies had left behind receipts.
And Hachika's for over $12 million, 0 cents in damages, plus $2,500, 0 cents to $25,000, 0 cents per photo used per game. It was one of the largest copyright claims against a game studio ever filed by a single artist.
Capcom denied wrongdoing and said they were still investigating the source of those assets. But let's be honest, the photo names didn't help their case.
The case, it didn't go to trial. It was settled privately in 2022. No public verdict, no official apology, but it left a big impact on how studios think about sourcing, textures, references, and background art.
Because when something as simple as a cracked window shows up in multiple cutscenes and your reference book came out 25 years ago, you better be sure you licensed that crack.
And this case wasn't about stolen characters or copied storylines. It was about realism and the fact that sometimes realism comes with strings attached.
Or in this case, jagged edges and metadata.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
In the world of mobile gaming, some battles happen behind the screen, literally, because this next case, it wasn't about monsters, music, or character design. It was about how your thumb moves.
Our scene begins in Japan. The year, 2018. Nintendo sues fellow Tokyo developer Colo over their hit mobile RPG Whitecap project. The accusation? Colo was using 5 of Nintendo's patents, including one for virtual joystick controls on a touchscreen.
To the average player, it just looks like a typical mobile game, swipe to move, tap to attack. But Nintendo argued those gestures weren't just intuitive, they were protected.
Specifically, Nintendo said Whitecap Project was using the same touch-based input method Nintendo had patented for the DS and 3DS, a method where a player moves a character by dragging their finger across the screen.
Nintendo demanded damages and an injunction, and at one point increased their claim to nearly 5 billion yen. That's around $47 million, 0 cents dollars.
Follow fought back hard. They denied infringement and kept the game online for years. But behind the scenes, the pressure mounted.
Finally, in 2021, 3 years into the fight, Colopel agreed to settle. They paid Nintendo 3.3 billion yen, around $30 million, 0 cents, and licensed the patents. That's one of the biggest patent settlements ever in Japan's gaming industry.
And what changed in the game? Not much that you'd notice, but Coloplay did quietly tweak Whitecap Project's input features to avoid any future risk.
This case proves something crucial. Game mechanics, not just characters or logos, can be patented. And if those mechanics are smooth, simple, and widely adopted, they might also be legally explosive.
Lesson learned. Sometimes the swipe of a finger is more than just control, it's innovation. And Nintendo protects its innovations like a final boss guards a treasure chest.
Every few years, a game comes along that the internet can't stop talking about. In 2024, that game was Palworld, described by some as Pokemon with guns, and by others as a lawsuit waiting to happen.
The developer, Pocket Pair, had clearly struck a nerve. You could catch little creatures, battle with them, and use them for everything from farming to factory work. Sound familiar? To Nintendo and the Pokemon Company, it sounded too familiar.
In September 2024, Nintendo filed suit in Tokyo, but this wasn't your usual copyright or trademark fight. They went in with patents, claiming Palworld had copied specific game mechanics protected under Japanese patent law.
One key issue, the creature catching system, throwing a ball, watching the animation, capturing a creature that then joins your roster. Nintendo said, that's not just the vibe, that's patented.
Another red flag, the creature designs. Even if they weren't exact copies, samples look suspiciously like Pokemon Tepekine after a few too many energy drinks. Twitter exploded, memes exploded, and so did legal speculation.
To be fair, Pocket Pair had tried to dodge a direct hit. They insisted Palworld was original. But after the lawsuit dropped, they quietly updated the game, tweaking animations, adjusting designs, and even altering capture mechanics.
As of now, the case is ongoing. Nintendo hasn't asked to block the game outright, but they're pressing for damages and changes. And Pocket Pair, they're walking the line, trying to keep their fan base while avoiding more legal fire.
It's rare for Nintendo to go the patent route first, but this case may mark a shift, especially in Japan, where major studios are starting to flex gameplay patents as their new legal weapon of choice.
And for indie developers out there, the message is clear. If you're building something inspired by a global franchise, check the artwork, check the names, and definitely check the patent register.
Because catching creatures is fun, but catching a lawsuit, not so much.
In the world of mobile RPGs, one mechanic reigns supreme, the gacha. You roll, you pray, you get duplicates. But what if the way you fuse those duplicates was patented?
That's exactly what Sega claimed in 2024. They filed suit against Bank of Innovation, the Tokyo-based studio behind Memento Mori and Cryptract. According to Sega, Boys Games infringed 5 different patents.
At the heart of the claim was a mechanic Sega said it pioneered. When a player receives multiple copies of the same character, those copies could be fused to unlock new abilities instead of being useless duplicates. Elegant, addictive. And according to Sega, legally protected.
The case hit Tokyo District Court in late 2024. Sega wasn't subtle. They demanded an injunction and 1 billion yen in damages. That's around $6,600,000, 0 cents.
Bank of Innovation denied any wrongdoing and insisted its systems were distinct. But in the core of public opinion, it triggered a bigger conversation. Can gacha mechanics be patented? And if so, how many other games are skating close to the edge?
For context, Japan has a long history of issuing patents for game system innovations, especially around UI and reward mechanics. So this wasn't a stretch, it was a warning.
The case is still pending, but it signals a larger trend, with Nintendo, Coloble, Pocket Pair, and now Bank of Innovation all facing patent litigation. The big studios are clearly saying game field isn't just about design, it's intellectual property.
And if your gacha game pops off unexpectedly, you might just roll into court.
In 2023, a greedy indie game called Dark and Darker appeared online, a dark fantasy extraction dungeon crawler with retro graphics and instant called buzz. But behind the torches and treasure chests, something much bigger was brewing, a legal war.
The game was developed by Iron Mace, a team mostly made up of former Exxon employees. And Exxon, they were not impressed. They claimed Dark and Darker wasn't just original inspiration, it was a stolen project.
According to Nixon, Dark and Darker was a shadow version of a canceled internal game codenamed P3. They said the idea, mechanics, and even code had been taken by devs who jumped ship and started over in plain sight.
So Nexon pulled out the full legal arsenal. They filed criminal charges in Korea for trade secret theft. They issued DMCA takedowns in the US. They had Dark and Darker pulled from Steam and blocked from distribution.
Iron Mace denied everything. They said they started from scratch, that they had the receipts, and that the entire thing was just a corporate overreaction. Fans took their side. They launched support campaigns. They played pirated versions. And when Steam took the game down, Iron Mace made it available via torrent.
That's right. They torrent distributed their own game, like a fantasy-themed BitTorrent Hydra.
In early 2024, a court in Seoul gave a mixed ruling. Iron Mace had not infringed on copyright since P3 was never released. There was no game to copy, but they had violated trade secret law by using internal Nexon knowledge to recreate key systems, even if the assets were new.
The court ordered Iron Mace to pay around 8.5 billion won, or nearly $6 million, 0 cents in damages. But they didn't block the game. Dark and Darker returned to Steam in 2024, still grimy, still playable, still surrounded by controversy.
The case is on appeal, but it raised one of the most difficult questions in game development today. What's the difference between experience and theft?
When a dev leaves a company, do they leave their ideas behind, or does a good idea always try to escape the dungeon?
In Argentina, the late Diego Maradona wasn't just a footballer. He was a God-tier legend, a national icon, and in 2017, he discovered he was also a video game character in a game he never agreed to be in.
The game? Pro Evolution Soccer, 2017, by Japanese developer Konami. It featured classic teams and legendary players. And there, running across the screen, was Ten Shaggy. Hand of God vibes, unmistakable dribble, no official name, but unmistakably Maradona.
Maradona was furious. He claimed Konami had used his likeness without permission, and he threatened legal action in both Argentina and Japan. The case sparkled headlines, not just because of who he was, but because of what it meant. How do you license a legend?
Konami's initial defense was that they had licensed rights through a club or a players' association, but Maradona said that may work for some players, not me. He had never signed his image over to any third-party agency.
Things escalated fast. Legal teams got involved. The press ran with it. And then something unexpected happened.
They settled quietly. Konami agreed to compensate Maradona and, in a twist, made him a brand ambassador for the PES series through 2020.
Maradona even announced that he would donate his settlement money to grassroots sports in Argentina, a dispute that started with anger, ended in partnership and legacy building.
It was one of the few cases where a lawsuit turned into a sponsorship deal, and it became a case study in right of publicity, especially for retired players who retain control over their image.
Today, Maradona has passed, but the case lives on, a reminder that fame doesn't automatically mean licensing, and digital immortality still needs a signature.
Even legends have lawyers.
Call of Duty has dropped players into dozens of war zones. And for many fans, realism is everything: the sound of boots, the click of a scope, and the iconic military hardware on screen. But in 2017, one of those vehicles decided it wasn't just part of the background, it wanted a say.
Enter the Humvee, or more specifically, its manufacturer, AM General. They filed a lawsuit against Activision Blizzard, claiming that Call of Duty had used the Humvee name, image, and design without permission in multiple games.
To AM General, the Humvee is a trademark product. They argue that its inclusion implied endorsement and that Activision owed them a license.
Activision fired back their defense: First Amendment, artistic expression. They said the Humvee was part of the battlefield just like it is in real life. It made the game more authentic, not promotional.
The legal test at the heart of the case was the Rogers v. Grimaldi test, a U.S. standard used to balance trademark rights with free expression. To win, AM General had to prove that the use of the Humvee lacked artistic relevance or was explicitly misleading.
Spoiler, they didn't. In 2020, the federal court ruled in Activision's favor. The judge said the use of Humvees was clearly artistically relevant to a realistic war game, and players weren't confused about sponsorship.
It was a big win for game developers, not just for Call of Duty, but for any game that depicts real-world brands, weapons, or vehicles for storytelling purposes.
Because games, like movies, don't need a license to show the world as it is. At least not when they do it right.
The case reaffirmed that IP law doesn't always override realism, and that sometimes the most iconic content just drives itself.
No license plate required.
Okay, we've covered the full campaigns. Now it's time for the speed run.
Quick cases, big consequences, no cutscene.
In this lightning session, I'll set the setup.
And I'll smash back with the verdict. Think of it as IP pickleball. Rapid volleys, weird rules, and someone's always one swing from a lawsuit.
These are the side quests no one planned for, the takedowns no one saw coming, and the pixel-sized lawsuits that pack a punch.
Grab your paddle. It's time to insert context and continue. Go.
Take-Two Interactive versus BBC, GTA. The BBC made an unauthorized Grand Theft Auto biopic with Daniel Radcliffe. Take-Two hit the brakes fast.
They sued for trademark misuse. The film aired, but with a big fat disclaimer. No stars were wanted.
Capcom versus Koei Tecmo Dynasty Warriors. Capcom claimed Koei's hack-and-slash games stole patented features like bonus unlocks and rumble alerts.
Japan's court said game on, Capcom got over $1 million, 0 cents. Even power-ups can be patented. Lindsay Lohan and Karen Gravano versus Take-Two, GTA 5th.
Pop star and the daughter of a famed New York figure both claim GDP used their likeness for in-game characters without permission.
New York's court hit pause. Satire is legal. GTA's parody meter stayed maxed out. Jim Brown versus Electronic Arts. Madden NFL.
NFL legend Jim Brown saw himself in Madden, but never signed on the dotted line.
EA settled for $600K. Even retired players need their rights drafted properly.
Atari versus Nestle breakout. Nestle's Kit Kat ad turned Atari's breakout into a chocolate arcade.
Atari wasn't sweet on it. They sued, Nestle crumbled and pulled the campaign. Blizzard versus Bossland, Overwatch and World of Warcraft.
Bossland sold cheat bots for Blizzard games, then ignored the U.S. lawsuit like a broken raid group.
Default judgment, $8,600,000, 0 cents. No risk rolls for cheaters.
Nintendo versus Mario Kart or Street Car. Mario Kart, a go-kart tour in Tokyo let riders dress up as Mario and Peach. Nintendo said, absolutely not.
Lawsuit won, name changed, damages increased. The only cart left was Street Cart. No shells, no stars. PUBG Corp versus NetEase. Rules of survival and Knives Out.
Krafton said NetEase dropped into the battle royale genre with full-blown PUBG clones.
They settled out of court. Game mechanics survived. Legal airstrike avoided.
Bandai Namco versus Ad Games, Miss Pac-Man. Ad Games made a retro console with Miss Pac-Man without Bandai's okay. Then they tried to buy the rights mid-fight.
Messy moves. Quiet settlement. Miss Pac-Man got ghosted from new releases. Ironberg Inventions versus Valve. Steam controller.
I'll get it back paddles to a Steam controller. Scuff said those buttons are ours.
Jury agreed. Valve paid $4 million. Gamepads aren't exempt from legal combos.
From parodies and power-ups to chocolate pixels and controller paddles, IP protection never quits.
And if you don't press license before pressing launch, well, it's game over with legal respawn costs.
After all these lawsuits and takedowns, you might be wondering, isn't there a better way to resolve disputes in the gaming world than waiting years for a court decision?
Well, enter the WIPO, Arbitration and Mediation Center, the low-key final boss of global dispute resolution. And in 2024, they powered up with new tools tailored for digital creators, game studios, and platform conflicts.
WIPO now offers faster, lower-cost alternatives to court battles, including online mediation and expert determinations for IP disputes. They've also created specialized procedures for video game and metaverse conflicts, including cases involving user-generated content, NFTs, esports rights, and character licensing.
Translation: instead of dragging each other through Tokyo, Paris, and California, two studios can sit down virtually and hash it out with WIPO's help. Private, cross-border, legally enforceable.
And it's not just for big studios. Indie developers, modders, even streamers can now resolve conflicts over contracts, royalty splits, or creative ownership without mortgaging their next game to pay legal fees.
So the next time someone copies your in-game mechanics or you get locked in a cross-platform licensing mess, you might not need to insert lawsuit to continue. You might just need to select mediation instead.
Because the game is evolving. And so is the way we resolve the fights that come with it. Before we log out, let's lock in 5 legal checkpoints from today's journey. The kind that apply whether you're a studio, an indie dev, or just a curious player watching from the loading screen.
From Nintendo's touchscreen patents to Ironberg's back paddles, the invisible parts of gameplay, how it feels, how it works, are sometimes the most legally explosive.
Whether it's Jim Brown in Madden, Maradona in PES, or a Humvee in Call of Duty, using real-world likenesses or brands without clear permission can trigger lawsuits unless it's transformative, artistic, or clearly part of storytelling.
Reviving an old game, building a new one based on what you learned at your last job. The courts are watching, and the difference between homage and infringement can be one shared file too many.
Whether you're in Seoul, Tokyo, London, or LA, if your game grows global, so do your legal risks. Choose your jurisdictions wisely and know how to serve up a takedown across time zones.
Borrowing the vibe of a hit game is one thing. Borrowing code, animations, or gameplay structure, that's how Sidequests turn into subpoenas.
So the next time you press start on your big idea, remember, creativity moves fast, but IP catches up. Remember to play the game IP Sidequests Showdown, available on our website. Inspired by this episode?
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.